How on earth am I supposed to find probable cause when Mickey Mouse is writing these reports? Every single day on the news, how many people die in our county because of a DWI?
If she can tell you whether there's a certain mole on me, then if she could tell you she saw that, then fine.
Despite doing all of those nice things for her, your testimony is that she just fabricated all of these things about you.
Yes.
Mr. Medina, you talked about all these nice things that you did for Leticia. Did that justify you putting her finger in
Charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. I see. So that he's also charged with abandonment. Is it out of the same transaction?
Yeah. We're down to old Judge Fleischer's court, and we got an interesting case today. This young brother's charged with DWI and abandonment. Abandonment generally relates to neglecting a child, but let's see what's going on.
We had a long discussion with him this morning.
I don't know anything about it. Let's find out what's going on, please.
5, an officer was dispatched to an unknown accident, and noticed a vehicle, a pickup truck.
Because this is misdemeanor court, the judge must first find probable cause in order for this charge to proceed. Probable cause simply means that a reasonable person will conclude that a crime occurred based upon what is presented to the judge. The state prosecutor is reading off allegations set forth in the police report. Let's see what happens.
Parts in the front yard of the residence. There were fresh tire skid marks, a broken wheel and axle, visibly appeared to be damaged from the Ram truck to a legally parked red Jeep Compass. The law enforcement officer made contact with the complainant, and then the defendant admitted to driving the truck. The officer also made contact with the wheel witness, who said that he witnessed the defendant in the white truck in the driver's seat behind the wheel and observed him exit the vehicle from the driver's side door. Upon exiting the vehicle, the witness observed he was not stumbling.
Hard to hear the assistant prosecutor there, but it sounds like someone witnessed this young brother stumbling out of his vehicle.
The wheel witness observed slurred speech and strong odor of alcoholic beverage emitting from the defendant's breath and person. The defendant also admitted that he was trying to clear the scene and go home, but his vehicle was stolen. The officer made contact with the defendant, who was detained, and noticed a strong odor of alcoholic beverage. The officer then conducted a standardized field sobriety test, where he witnessed, Your Honor, the DIMS leaves off and does not show the standardized field sobriety test results. The officer asked the defendant his intoxication level. The defendant said he was at a 6 out of 10.
This doesn't sound like the best written police report, and it appears the officer asked this young brother his level of intoxication, and he said 6 out of 10.
The defendant said he does not believe it was safe to operate his motor vehicle at this level of intoxication, but had an 11-year-old passenger.
He did not.
I'm sorry, he did not. He did not. I apologize.
Whoops.
Judge, I'm going to tell you that's kind of where the DWI investigation stops. The first response that I have is that no field sobriety tests were performed. Also, the credibility of the wheel witness was never discussed in the DIMS, whether the officer found them credible or reliable, etc. I really can't make a lot of sense out of...
It's like the DIMS you're reading these like going through a drive-thru, man. I mean, really, who's writing the reports?
Yes, Your Honor.
Over and over and over. I mean, really. Case after case, we're just...
DIMS don't say it. Don't say what is the results of those field sobriety tests, and we do not have an officer.
So the report doesn't even have the results of the field sobriety test, and all we have now is this young brother judging himself a 6 out of 10.
How on earth am I supposed to find probable cause when Mickey Mouse is writing these reports?
I don't know why it's not in the DIMS. Obviously, we didn't write it in here. We represent what is written in there. I understand your frustration.
Mr. Kubler, I'm going to find no probable cause in your case.
There is the old gavel, no probable cause because of the shoddily written police report.
Kill anyone? Every single day on the news, how many people die in our county because of a DWI? How many?
12.
Every single day. We lead the nation in alcohol-related collisions and fatalities because of boneheaded moves that are made day in, day out.
At least they're winning in something.
This is not to say that they may not indict this case at a later time. Just don't kill someone, please. Take a seat, please, sir.
And there you have it. The young brother escapes the DWI charge for now. As the judge said, he can potentially be indicted for this crime in the future if they uncover more evidence with regard to what actually occurred. But for now, the judge has decided that there is no probable cause that this young brother committed the crime of DUI in Texas.
The defendant entered a plea to the lesser included offense of aggravated assault of a child. Punishment is to be assessed at cap 15 years in the prison. There's a $1,500 fine. and the state is opposing your application for deferred adjudication.
We're down in Bear, Texas, in old Judge Boyd's court. This is a pandemic case, but it's a really interesting situation. A grandfather is accused of molesting his step-granddaughter. He's facing up to 15 years in the prison. He's requesting a form of probation, which will allow him to avoid any jail time.
Have both parties had a chance to review the PSI report?
Yes, Your Honor.
Yes, Your Honor.
This is a critical aspect of this case. The PSI report is a pre-sentencing investigation report. In that report, there will be facts that both parties agree to. That's critical because you cannot come to court and argue different facts. Therefore, it's critical if you're the client or even the state that those facts reflect the actual facts for which you agree to.
Defense, do you have any witnesses?
I do, Your Honor.
Who's your witness?
A daughter and two daughters and a wife. Crystal, in what relationship are you to Mr. Medina?
I'm his daughter. I just want to thank you for this opportunity to address the court on behalf of my sister and I.
A sworn witness should not be reading any type of statement. There should be question and answers. I would object immediately to this type of testimony if I was a state.
I'm very aware of the allegations that my father has been accused of, but those allegations are false, Your Honor. So I would like to say a few words. I've had my dad in my life for almost 4 years now.
We're going to object to the narrative aspect of this line of questioning.
All right, that'll be sustained as to narrative.
A narrative objection will be sustained if the witness is simply just telling a story and not answering any questions.
Do you want to just, in your own words, tell what your father has been to you?
He's just been there for everything, for every birthday, every holiday, every major event. He's been in my kids' lives, my sister's lives, for almost 40 years now. I mean, he's just my everything. He's my dad.
All of that is irrelevant with regard to whether or not he actually attacked the child. All right, so here's his wife, and let's see what she has to say.
And Miss Medina, what relationship, if any, are you to Eddie Medina?
I'm his wife.
And how long have you been married to Mr. Medina?
We've been married 22 years.
Okay. Do you suffer from any physical ailments?
Yes, I'm legally blind.
Okay. And do you have doctor's appointments?
Legally blind? Then how could she witness anything her husband's doing if the allegations are true?
And things like that?
Yes, I do.
And so Mr. Medina is basically your sole source of transportation?
Yes.
And income?
Yes.
All irrelevant.
No further questions.
Call your next witness, please.
I have no further witnesses, Your Honor.
All right, then the court will hear argument. State.
Yes, Your Honor. So the state is asking that you deny his application for deferred adjudication and that you sentence him to the full 15 years in prison. And that's based on a number of things. First, I think the court has to look at the facts of this case as has been stipulated by the defendant during his plea. We have obviously egregious conduct, any type of sexual touching or interaction with the child.
This prosecutor uses so many connectors in his speech. If you notice them in your speech, you must eradicate them straight away or seek help from a professional on how to remove connectors from your speech. Because oral argument is so important as an attorney, you must be able to remove connectors from your speech.
Obviously concerning and in and of itself might deserve prison, but the aggravating factors on this case, Your Honor, is that the length of period of time that this occurred, the age of the child when these allegations first started happening, and then as well as the aggravating factors of kind of the threats that he gives in order to prevent the victim from coming forward and her feeling to be able to come forward with the fact that her step-grandfather has been touching her for a number of years. Then I think we have to look at the conduct of the defendant during his sentencing, and most specific, obviously, during the PSI. It's very clear that he minimizes his guilt. And what's even more concerning, Your Honor, is, you having dealt with these types of cases, your career.
The minimization is important during sentencing. The facts are stipulated to, but the judge wants to see, is this defendant someone who is actually authentically sorry for their action, or are they minimizing their actions by providing excuses or blaming other people for their actions? Let's see.
Kind of classic behavior of him projecting the culpability of this case on the victim and not on him, for him not being able to keep his hands off of as young as a 6-year-old child. And we see him saying things like, she's wearing low-cut blouses, and people
wearing low-cut blouses, the 6-year-old.
People were telling her about sexual behavior. On page 13, where he says she was way ahead of her time and she was sexually advanced.
Sexually advanced as a 6-year-old? That doesn't make sense.
He comments like, if this happened, why didn't she say nothing to her mom? Why wait 4 years to say something? I think the court is well aware when you make threats to a child, nobody's going to believe them, that or something might happen to them if they come forward, that they've been being abused. That might be a reason they don't tell their mom. That might be a reason why it takes them over 4 years to make an outcry of what's happening to them. Also, I see that, you know, in looking at this, he doesn't look about what has happened to the victim and how this has had consequences, not just on her life, but everyone who touches her life.
Bad choice of words there, talking about everyone that touches her life. But with regard to what he's saying, it's accurate. We want to see some culpability on behalf of the defendant. It's not time to argue the fact that it didn't occur. That ship has long sailed. If you stipulate that it did occur in the PSI report, there's no way around it now.
Page 12 says, I don't know why she would do this to me. Well, I think the better question, Your Honor, is why would he do this to somebody so young, somebody who's related to him, and most importantly, a child? Can't forget that. And so we're asking that you deny his application and you appropriately sentence him to the maximum under the plea term, which is 15 years. Thank you.
Defense?
Yes, ma'am.
No, excuse me. Are you going to testify?
I think he just wants to make a statement.
I just want to make a statement, ma'am.
Well, I mean, I can place you under oath and you'll be subject to questioning.
Do you have a statement you wanted to make to the court?
You know, ma'am.
Let's see if he minimizes his actions or takes some form of accountability for what he did.
Everything that the gentleman just said and accused me of, you know, the blouse and lowering the blouse. All that time she was coming to our house.
The attorney's shaking his head no, and he knows it's not the time to argue the facts of the case. You stipulated to the facts. Everything the prosecutor read is something that you agreed to and the judge is going to hold as true. That's critical to this case. Coming before the court now and saying that the facts which you agreed to are not true will only harm his case.
Way before all this has happened. She was coming to our house. She was spending the weekends with me and my wife. She was going swimming in my swimming pool. And as she started to develop, well, I started telling my wife, she started wearing low-cut blouses, showing her breast. And I kept trying to tell her, in front of my wife, you need to pick up your blouse. Pick up your, I don't know why your dad's not letting you wear that, to pick up your blouse. So I did tell her that, to pick up her blouse. Then me and my wife were talking in the bedroom, and she has in the bathroom. The bathroom and our bedroom were kind of adjacent to us. And of course, she started her monthly. And I told my wife, she needs to let us know when she's starting. That way we can have the proper equipment for her. Okay? So she heard it and she came out kind of upset. And I tried to tell her, you need to talk to us and let us know. That way we can have this stuff, because
not the easiest subject to talk to your step grandfather about.
Me and your mom, we're grandparents. We don't keep that stuff. Like, you know, I'm 64 years old. My wife is 54. So my wife doesn't have that anymore. You need to let us know what cycle you're at. That way we can have these pads for her. And her spending the weekend with us, you know, my grandsons, I got grandsons, I got nephews and nieces. You know, all this stuff that she's accused of me of doing really, really startled me and my wife and my family members that are back here, my sisters that are supportive of me of all this allegations that I am getting. You know, I've never been in trouble. I've never been in.
Listen to all the projection and deflection. This doesn't help his case because he's not taking any type of responsibility or showing any remorse. All he's doing is providing excuses why the facts for which he stipulated to are not true.
You know, besides what he said about me and my wife had a little conflict, I just retired, and you know, and all this stuff that gentleman is saying about my granddaughter, I love her, as I love my other grandkids, you know, and it just hurts me to hear all that, because all these birthdays that she had, she would come over to our house. She would spend the night at our house. She would sit right next to me and show me her coloring that she was drawing and so forth on. So, you know, Your Honor, I just don't understand, you know, why she, you know, I can't understand why, because where she grew up on the other side of the family, you And the reason
Now he's going to blame the other side of the family.
he was saying that she was well mature, well, she was, because she had aunts that would tell her all these other stuff that grown-ups should only know.
Now Gramps is blaming the slutty aunts from the other side of the family.
And the reason we know is because my daughter that just passed away, she would tell us. She would tell my wife and us that she's well ahead of time. And we kept trying to tell her, don't send her over there. Don't go over there to it was the Dimas family. Don't go over there because, you know, they've been involved with DPS, police, all over.
All right, sustained.
Their narrative objection is sustained again.
Anyway,
That's enough.
okay. I'm sorry. That's enough, Judge. Sorry about that. I just had to do
State, any questions?
I sure do. Mr. Medina, you talked about all these nice things that you did for Leticia. Did that justify you putting her finger in her vagina?
I didn't do that, sir. No.
Does it?
I didn't do that at all. At all.
Does it justify you making her touch your penis?
Sir, if I did that, there is if she can tell you there's a certain mole on me, then if she could tell you she saw that, then fine.
This is not the time to argue whether or not the assault occurred. He already agreed that he did those actions. Coming up with the mole theory does nothing to help his situation right now.
None of that's happened. None of it.
So you did all these nice things for her.
No, I didn't do all those nice things for her. I didn't. It was because she was our granddaughter. Me and my wife did it, not just me.
Mr. Medina, how this works is I ask a question and then you answer it, okay? So
Yes,
I'm asking my next question. Despite doing all of those nice things for her, your testimony is that she just fabricated all of these things about you.
Yes. Yeah, because, I mean, my wife was there all the time. She was there all the time. My daughter.
Your wife is legally blind. She couldn't see anything. And it doesn't matter. You already stipulated that you did all of those things in the PSI report.
Now that she passed on, she was there all the time.
His other star witness happens to be his dead child.
My stepson lived with us at that time. I mean, everything happened there at the house, what she's accusing me of. And my wife, I would tell her, she said something to one of them that I bathed her. I never bathed her.
I'd never bathed any of my kids either.
Bathed her. Never. I don't know where she's got this bathing that I bathed her. I never did.
Okay.
And I would tell my wife,
you did all these nice things for her. She just makes up these allegations. And we're not talking about bathing here. We're talking about things like you putting your finger in her vagina and that you making her touch your penis. She just made all those things up.
I never did, sir. I never did. Okay. I'd be the first one to tell you, yes, I did. I'm a former Marine, sir, and I would tell you right from the get-go, I would never, ever, ever do anything like that.
Sounds like he just said, I'm a former Marine again. By saying he's a jarhead, he wants to elicit more credibility for his arguments. The problem is he already agreed to all of these actions in the PSI report.
That to my grandkids, never. I have.
Mr. Medina, yes or no answer. You're doing all these nice things for her. She just made up allegations about you putting your finger in her vagina and other things like making her touch your penis. She just made those.
She never did.
Judge, I'm going to object. That's already been asked and answered numerous times.
Never did, sir.
That'll be overruled. And the defendant has just, if you can answer the question, please.
No, sir. No, sir. No, ma'am. I never did any of that. Never.
So she made it up.
I'm assuming she did, sir, because I'll be the first one to say,
thank you, Judge.
I did.
There are situations where a child will make up these types of assaults. And the data indicates it's about between 2 and 10% of these cases. So if you're representing someone like this, you have to analyze why someone would actually lie in this situation. But that must take place before you have your client agree to these actions.
If I did all that, I guarantee you.
Too bad you already agreed that you did it.
I guarantee you. My family members that are back here, my sisters, my brothers, my wife, my 2 daughters wouldn't be here with me at all.
All right. The state is opposed to the application. What are you asking for, Mr. Churak?
Judge, I'd ask that you put him on deferred adjudication probation, and if not, sentence him to the minimum of 5 years.
His attorney's asking for deferred adjudication, which is a form of probation, which would prevent him from going to jail. The state is asking for 15 years.
The court is denying the application. The court will find you guilty, sentence you to $1,500 fine, time and money to run concurrent. Chapter 62 registration, and the court will sentence you to 15 years in prison.
There's the old gavel. Judge Boyd did not buy any of Grandpa's excuses and sentenced him to the maximum per the agreement of 15 years in the prison, along with Chapter 62 registration, which is Texas's form of sexual offender registry.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it? No problem. Did you review this document with your attorney? Did you understand it? Did you electronically sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain.
The family's crying out there, but they should have known coming in this was not the time to argue whether or not the actions occurred. Grandpa agreed to the facts that he did insert his finger in his step-granddaughter's vagina. He agreed to it. If he disagreed, his only other option would be to go to trial, and then he would make the arguments that he was making today.
Agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
Now, there are situations where a defendant could agree to facts for which he doesn't believe are true. For example, if he's facing up to life in prison, he may decide it's better to take his chances on 15 years and simply agreeing to the facts. The only two people that would ever truly know are Grandpa and the step-granddaughter. Because the judge is obligated by the law to actually follow the stipulated facts, all of his counter-arguments did nothing to help him here.
All right, good luck to you, Mr. Medina.
And there you have it, 15 years in the prison for bad Grandpa. If he truly wanted to fight the allegations, he should have done it at trial, not during his sentencing phase. You never know if he is innocent or if the alleged victim is lying. I want to know what you think in this situation. I was swaying both ways with regard to how I felt, but in the end, I must rely upon the law, which sets forth he agreed to these terms, he agreed to the facts, and therefore 15 years is an appropriate sentence because the parties agreed to it.